Assalamualaikum warahmatullahi wabarakatuh. We are from Group 8 and we're going to discuss about what we have been analyzed from the criminal report since 2020 until 2023. I'm Amira Yasmin binti Muhammad Khairul Anwar using number metric 070469.
Did you guys know that there are two types of crime index, which is violent and property crime? Violent crime consists of murder, rape, robbery, and causing injury. Property crime basically comprises house break-in and theft, vehicle theft, and other theft. However, the topic that we will be focused on and we will be discussed today is one of the violent crime, which is murder and culpable homicide. Did you guys know what is murder and what is culpable homicide? Okay. Murder is a crime that purposeful and illegal killing of another victim. However, culpable homicide frequently seen as one of the cruelest offenses in international law system. To begin with the definition of murder, primary characteristic of murder is usually the intentional and conscious act of causing the death of another person with the purpose to do so. The first act that was intended to cause death is one of the reasons it will call murder. Murder can have some effects such as long in jail terms, life in prison, or in specific situation, the death penalty. Moving on to the culpable homicide. When someone kills someone else without permission, it's known as culpable homicide and the accused is legally accountable for their conduct. When they knowingly kill someone else without having the required intention to commit murdering someone, or when they kill someone else due to the stupidity or irresponsibility. Culpable homicide have been clarified into various degrees, which is killing someone or voluntary murder. These differing levels may consider elements like the accused's intentions, mental states, or level of negligence. It is essential to remember that different legal systems may have different definitions and possibility for culpable homicide. To fully comprehend the possibilities and punishment that accompany culpable homicide in a given circumstances, it is important to consult the relevant jurisdiction-specific laws and regulations. That's all from me for the definition of murder and culpable homicide. So moving on to our second part of discussion, which is the statistic. Analyzing from the statistic given by the Department of Statistics Malaysia, violent crime can be used as proxy indicator in the Sustainable Development Goals, specifically under Goal 16. What is Goal 16? Goal 16 it focuses on promoting peace, justice, and strong institution. All of the people should be free of fear from all forms of violence and feel safe as they go about their lives, whatever ethnicity, faith, or sexual orientation. So, starting from 2019, murder cases has been recorded with the total of 310 cases. However, in 2020, following the spreading of coronavirus and Movement Control Order or MCO by the Ministry of Defense, the crime index has been decreased by 57 cases, which the total cases of murder cases in 2020 is 253.
My name is Nur Shazwani bint Abdul Halim, 070068. So due to the population increasing, the reason of crime happen may be vary, especially in the mens rea. The reason is very complex and multifaceted. So it is crucial to note that trends in crime, including murder, are influenced by a combination of social, economic, political, and environmental factors. And in some cases, people suffering from high level of poverty and economic inequality tends to contribute the criminal behavior to happen due to desperation. And apart from other reasons, we have found that untreated mental health issue can potentially contribute to instances of violence, including murder for some reason. And it is very essential to approach the relationship between mental health and violence with nuance and avoid stigmatizing individuals with mental health conditions. And based on the statistic analyzed, we have come to a conclusion that the crime index is the indicator of a country's crime cases. And the crime cases especially murder on percentage have lessened year by year, but with a small amount only. And this clearly shows that the potential of crime cases increases by 2023 is high, and our movements are now is not as restricted as before. We believe that all factors may contribute into murder being committed by a person, but the judgment will only determine the punishment of the case. Thank you.
Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Mida Hazimah binti Mahadan, matric number 070234. I am from Group 8 and today we are going to talk about culpable homicide cases in Malaysia and defences and offences available to accused under Malaysian Penal Code. To begin, murder and culpable homicide are two of the most common crimes in our country. In certain legal system, culpable homicide is defined as the crime of murdering or causing their death but not willfully. According to Penal Code section 299, anyone causes death by committing an act with the goal of causing death or with the intention of inflicting such physical damage as is likely to cause death, or with knowledge that he is likely to cause death by such act, commit the crime of culpable homicide. In the case of Mardana Sida against State AIR 1985, it had mentioned that the accused was found guilty of culpable homicide when the accused used a stick and delivered some blow against the head of the deceased. The accused harbored the intention and knew that such blow were likely to crack the deceased's skull. It was held that the accused knew well of his action that was likely to cause death to the deceased. Moving on to the next issue, which is murder. In section 300 of the Penal Code state that culpable homicide is a murder case if the conduct caused death with the purpose to cause death. Next, the offender is aware that the conduct is likely to result in the death of the person to whom the harm is done if it is done with the aim to inflict physical harm. Following that, the conduct was committed with the goal of causing bodily harm to any person, and the bodily harm intended to be inflicted is sufficient to cause death in the usual course of nature. Finally, if the person conducting the act is aware that it is so imminently hazardous that it must in all likelihood result in death or bodily harm that is likely to result in death, and conduct such action without any justification for incurring the risk of causing death or bodily damage as stated. For instance, in the case of State against Surya Narayana, it was stated that the accused was guilty of the offence of murder. It was because, in this case, the accused wanted to kill a person who had insurance coverage, and the accused gave some halva, which is a sweet meat that was spiked with arsenic and mercury, to the intended victim to cause death, who at that time was at the accused's brother-in-law's house, tasted the food and discarded it because he disliked the taste of the food. Without the knowledge of the accused, his brother-in-law's son had picked up the food and shared it with his friend. Both of the children died while the intended victim survived.
My name is Amirul Nakib bin Amiruddin. My number matric is 069420. Section 299 of the Penal Code states that whoever causes death by doing an act with the intention of causing death or intending to cause such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offence of culpable homicide. The punishment of this offence not amounting to murder as provided under Section 304 of the Penal Code. This section contains two punishments, which imprisonment for a term which may extend until 30 years and shall be liable to fine. This punishment to be awarded to a person who is found to commit the offence with the intention of causing death or of causing bodily injury as is likely to cause death. The second punishment is imprisonment for a term which may extend to 10 years or with fine or both. The accused will be punished with this punishment when the act is done with the knowledge that it is likely to cause death, but without intention to cause death or to cause bodily injury as likely to cause death. Culpable homicide is considered murder except in certain cases. A murder occurs when a person intends to cause death, the person intends to cause bodily harm that they know is likely to cause death, the person intends to cause bodily harm and the intended harm is likely to cause death in the ordinary course of events, the person knows that their action is dangerously likely to cause death or serious injury and they do it without any valid reason for taking such a risk. The punishment for murder stated under Penal Code Section 302, the punishment for the accused shall be punished with the death sentence. Section 299 uses words that are similar and closely connected to the definition of murder in Section 300 of the Penal Code. Essentially, all acts of murder under Section 300 are also covered under Section 299. However, if the accused can prove a special exception to Section 300, such as provocation, they will be charged with culpable homicide instead of murder even if they intended to kill. To determine whether the accused had the intention to kill, various factors should be counted, such as the nature, location, quantity of injuries inflicted, the method of infliction, the characteristics use of weapons, and consideration between both parties. In the case of Ismail Hussein against public prosecutor, the appellant was convicted of the murder of Omar and the attempted murder of Rifin. He claimed to have mistaken them for terrorists. Omar died instantly from the wounds. Held that the evidence as a whole shows that the accused saw a man and shot him at close range, may support to the conclusion that he intended to kill, so the intention was formed. The intention was to kill that amounts to murder. As regards the shooting of Rifin, it is not unusual to fire a shotgun at a man's leg to prevent escape and the like, where there is a definite intention not to kill. The second conviction should therefore have been for causing grievous hurt.
Hi, my name is Nuraina Hayati binti Karya Anwar. My number matric is 071432. A criminal defense is a strategic argument that attempts to undermine the validity of sufficiency of the prosecution's evidence. The prosecution must prove the beyond of the reasonable doubt. There are several ways that can be used to resolve your charge as criminal defense. As first, intoxication. According to Section 85, Clause 2 of Penal Code, drunkenness may be a defense to a criminal charge if he did not know at the time of its commission that the act or omission was inappropriate. He had no control over his drunkenness states and he had no intention of harming anyone. Additionally, a person's intoxication was temporary until the act or inaction was completed. According to the newspaper, the driver was driving under the influence of alcohol. He crashed into a four-wheel drive vehicle before colliding with another vehicle, resulting in the death of Alam Flora Sendirian Berhad supervisor, that was Irman Herman. According to Professor Dr. Syamrahayu Aziz, the lecturer of International Islamic University Malaya, the criminal code can be applied to all types of deaths, including deaths caused by drunk driver. The defendant was detained in penal prison awaiting trial at the request of deputy prosecutor under Section 300 of the Penal Code with summary of Section 302. Next, acts which are offence independently of harm caused to the person consenting are not within the exception in Section 87, 88 and 89 also can be used as a criminal defence. Section 91 of the Penal Code provides that the exception provided for Section 87, 88 and 89 do not regulate acts that constitute a criminal offence, regardless of the harm they cause to the person who gives their consent or on whose behalf it is given, can inflict, should inflict or is known to inflict. In the case of PP against Dr. Nadasen, was accused of intentionally caused a woman to miscarry, which was done without good faith or intent to save the woman's life. The court confirmed the charge conviction and rejected his theory, supported by experts, that he had the abortion to avoid the risk of pulmonary embolism that could arise from the hypertrophy of varicose vein in women. The court concluded that this argument was not justified under existing law and the abortion was a serious matter that should only be performed as a last resort to save the woman's life or prevent her from becoming a mental health disorder. Dr. Nadasen was charged under Section 312 of Penal Code that causing the miscarriage. However, he testified under oath and defense that he had performed the abortion in good faith to save the life of women suffering from severe of enlarged varicose vein that could cause a pulmonary embolism.
Finally, we have come to the end. To conclude, culpable homicide and murder are one of crime amounting to the mandatory punishment, which is death. There are many offences that are not mentioned above that can lead to both crime. However, if the offender is convicted with culpable homicide and murder, there are some general exceptions that are available in the Penal Code that can be used as a good defense. To exercise this Chapter 4 of Penal Code, or in other words its general exception, the offender or defendant must prove his act free from the elements stated in Section 299, which explain culpable homicide, and Section 300 that amounts to murder. The defense of culpable homicide and murder in Chapter 4 of Penal Code or general exception can be used as a good defense if actus reus and mens rea can be proved that the event was unintentional and it was an accident on behalf of the defendant. Other than that, the other evidence must be enough to ensure that the specific section among the section in general exception can be argued as a good. Both culpable homicide and murder have the similarity, which are the act of offender amounting to death of a person. The differences are culpable homicide more to the accidentally event. Even the offender have a knowledge toward his action and know the consequences, and for murder is more to the deliberate act of the defendant that have intention of causing death and know the consequence that his act can amounting to death or bodily injury to the. Lastly, the penal code of our country is a complete act that include the offences and the defences in the specific chapter. However, even though the penal code had gathered the punishment of offences, the rate of crime in our country still increases from time to time. Therefore, judiciary must act transparently toward this issue to prevent worse crime occur. As we can see, through the year, corruption is the aftermath of the accused escape his wrongful act. Thus, the plaintiff does not get their justice. Therefore, judiciary must act transparently toward this issue to prevent worse crime occur. As we can see, through the years, corruption is the aftermath of the accused escape his wrongful act. Thus, the plaintiff does not get their justice.